Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. So here in the series, we've been covering 4 fundamental questions of property law. And today we are covering the third fundamental question, or at least I consider it to be fundamental, which is how do we use property? Really, how does the law allow us to use property? And today we're dealing with something of a difficult subject, but I hope you bear with me and see that there's some light on the other side. So when you think about a nuisance, you might think of noxious uses like polluting factories or mining operations. We've given those examples in other videos. You might not think that courts have used nuisance law to, at least in the past, use nuisance law as a tool to exclude people who, in their view, were undesirable. So what kinds of people might be considered undesirable by courts? Perhaps low-income people, immigrants, perhaps people of color. You'd be wrong if you assumed that courts never did that. So I'll point you to a couple of resources on this. 2 authors, Alfred Brophy and John Nagel. They've both written about the use of nuisance law to exclude people on grounds of race, also on the grounds of morality. Also, in a more recent article, Tajania Henderson and Jamila Jefferson Jones, in their article, Blackness as Nuisance, illustrates how this sort of concept, the use of nuisance against people, has been applied and continues to be applied, particularly to Black Americans. Other examples of people-based nuisance actions are out there. So for example, a sex offender might be written into local ordinances to be a public nuisance if he or she lives in a residential neighborhood. And that you might say, well, I don't know, that you might say, well, people feel justified in thinking that that is a nuisance. Other cases, are even harder though. There's a case where neighbors tried to claim that a boy who was autistic was himself a public nuisance. So there's a wide spectrum of these cases out there, and they're problematic in a variety of respects. I do want to mention before we get to nuisance law, actually a zoning case, which is Euclid versus Ambler Realty that went up to the Supreme Court in 1926. I want to just tell you what they said about apartment houses. They said that an apartment house is, quote, a mere parasite constructed in order to take advantage of the open spaces and attractive surroundings created by the residential character of the district, of a single family district. And that's the quote. And we all know who elites like Supreme Court justices think live in apartments. Even though that case was 100 years ago, and even though it was a zoning case, not much has changed in the way that we view certain populations. We'll talk about that a little bit more when we talk about zoning. So if people and even courts think of other people as nuisances, is there a way to address that? And so I've linked in this video, and I suggest that the Fair Housing Act, Title 8 of the Civil Rights Act, passed in 1968, is an attempt to address that feeling. It's one of many that we need to do to address that feeling, of course. But let's get to what the FHA says. So the FHA says that you can't discriminate against individuals in renting, in sales, in advertising, in financing, in mortgage lending, and other aspects of the housing market. You can't discriminate on the basis of race, color, religion, disability, sex, familial status, the presence of children under 18, or nationality. So the Fair Housing Act protects those categories. It doesn't, however, protect others. So consider sexual orientation, creed, marital status, income sources, or income levels. In addition to those areas that it does not protect, there are 5 specific exemptions that I thought I would mention today, exemptions from the Fair Housing Act. So the first one, single family homes that are sold or rented Those are exempt from the Fair Housing Act. Owner-occupied housing, if there are fewer than 4 dwelling units. So we have nicknamed this exemption the Mrs. Murphy exception. So the exemption, however, does not apply to advertising. So we want Mrs. Murphy's racism or sexism to be under the surface. We don't want for her to advertise it, even though we recognize that as a small-time landlord, she might want to do that if she's living in the house. Third category, religious organizations. So religious organizations can limit sale, rental, or occupancy to people of particular religions. Another exemption in the Fair Housing Act are private clubs. So private clubs who have lodging may discriminate in their lodging if it's limited just to members. And then finally, and this is an interesting one for me, age restrictions for age-restricted communities. So if a certain percentage of residents are 55 or older, in some cases 65 or older, in other cases, you can make that age required of residents. You can even, under those same principles, ban grandchildren from staying overnight. So this is one of the few times that you can legislate or discriminate on the basis of familial status. And again, I just told you the Fair Housing Act doesn't even cover age. So I mentioned this as a fifth thing to keep in mind. In that case, the discrimination against familial status. So the Fair Housing Act also treats the disabled, it provides special equal opportunity to them. It enables them to have reasonable accommodations when those accommodations may be necessary to have equal opportunity to enjoyment of property. And in that scenario, reasonableness is sometimes analyzed under a cost-benefit analysis. It's sometimes analyzed as to whether a permit or zoning change would be granted for traditional residences when dealing with zoning boards. Whether something is necessary usually just includes physical accommodations. It doesn't include accommodations to make housing more affordable. And that's something that many people are surprised to think about. So you can't justify, if you're a person with a disability, a reduction in rent on the basis of the disability, even if your disability means you don't have enough income to be able to purchase or rent a unit. Under the statute, that's not necessary. A person with a disability must also be allowed to make reasonable accommodations to his or her unit. So the Fair Housing Act, again, has specific accommodations for people with disabilities. So just stepping back big picture, given the number of people who are upset by racial segregation, class segregation, treatment of people with disabilities in the United States, and given that the Fair Housing Act is on the books, why is it that there are so few cases dealing with the Fair Housing Act, dealing with discrimination in housing? And there are a lot of practical reasons for this. Perhaps the biggest is that there's no money at the end of it, and litigation can take 5 to 8 years. So the kinds of attorneys willing to take on Fair Housing Act cases are fairly limited. You might also consider that housing developers that see zoning bodies or local governments discriminating might not want to sue those governments because they are repeat players and don't want to be considered to be troublemakers. You might also consider the fact that people might not want to be plaintiffs in these cases. They might not want to push their way into neighborhoods where they're not wanted or where they are considered nuisances. So there is so much more that we could say. There's whole classes that are taught on this topic, but I thought, linking the concept of people as nuisances with the Fair Housing Act might give you a window into the kinds of issues that the Fair Housing Act was intended to address. In addition, since this is Property Law 101, my hope is that this gives you just enough to want to learn a little bit more, which is, after all, my hope for any class. So I will leave it there. I look forward to hearing from you on Twitter or through my website, where you can sign up to my mailing list, and I will see you next time. Thanks.